week it's been. Every week in privacy and data protection seems to be busier and busier. Welcome all. Thanks for joining our weekly privacy chat. This is not just a privacy chat this week. This week we are also having one of our FPF book club events. As you know, every so often we find a book that we think all of you in the broad policy and tech and privacy land ought to be reading. I know you're busy. I know you're reading state laws. I know you're reading global laws. I know you're dealing with just a flood of information, but you got to pause every so often and see some of the big picture so you know how to make sense of what's going on. And so I'm delighted to have somebody who's helped me over the years make sense of what's going on, Mark MacCarthy. Mark, I met, I guess, when he was at Visa. I learned when perusing his broader bio that he actually, like me, spent an earlier chunk of time, formative years on the Hill, working for a strong member of Congress who really had impact on in a wide swath of the U.S. economy. And Mark and I worked closely when he was at the SIIA, and now today, Mark teaches at Georgetown, thinks big thoughts at Brookings, is affiliated with us here at FPF, where we can impose on him for some advice and input every so often. And one of the reasons I'm thrilled that he wrote a book is I deeply appreciate people who can work across disciplines. You know, it's when you're in the academic world, you've got to write and think in a certain way. You've got to build on earlier scholarship. You've got to sort of show how your work fits into sort of a theme of scientific development. And of course, civil society has to advocate and argue and so on and so forth. And the industry's got their views. And it can be very hard to sort of understand the big picture of all the forces that actually result in policy making. And Mark is one of the people who has spent time in each of those buckets, and today has the liberty to think those thoughts based on his experience. So congrats on this new book, Regulating Digital Industries. I love the book. I disagree with the premise, and let's see if Mark can convince me that the work he did here to really flesh out the arguments makes the case for public oversight, how it can encourage competition, protect privacy, and ensure free speech. Buy it at your favorite bookseller. Let me just recommend one other thing about this. What surprised me, because I thought it was going to be an argument about regulation, and there's a lot of that, but it's a great tour de force of most of the significant, interesting policy debates and issues of recent years. And even if you're going to put aside the very specific who and how should we effectively regulate, I'm recommending it to some of the people over here around the office just as a good primer about a wide swath of the tech policy issues that are on the table. So congratulations on this. But Mark, why this topic in particular? Why is this the compelling thing that you devoted 400 plus pages and footnotes to making a case for? Is this what we need? Is this where we start?
So great questions. And Jules, thanks so much for doing this. I put a little bit of time into the book, and it's wonderful that you're devoting this segment of your show to a discussion of it. And thanks also for noticing that the book is more than just a sustained argument for a digital regulator. It is that, and I think that's its major takeaway. But to get to that, I had to go through in detail some of the proposals in competition policy, in privacy, and in content moderation, and sketch out roughly the lay of the landscape in those three policy areas. And that was an intrinsic part of the argument. If you look at how these policy areas are developing, and you see what's being proposed in each of them, you see that in each of the policy areas, you need a regulator in order to make the policies work. I think that's sort of obvious in some of the areas, especially privacy. The Europeans have had a regulatory structure there since 1995, and other countries, when they set up a privacy regime, almost always set up a regulator to enforce it. So it seems pretty obvious there. And in moving towards regulation of content moderation, like the Online Safety Bill in the UK that just got passed, or the Digital Services Act in the European Union, also you seem to point to the need for a regulator. In Europe, it's Ofcom, their media regulator. In Europe, it's one of the DGs, DG Connect, that is responsible for enforcement, along with some role for the national regulators. The innovation, I think, is to think about competition policy as in need of a regulator. In the past, in the United States especially, it's been looked at on as a species of law enforcement. You bring a case to a judge, you make an argument, you find someone guilty of an offense, and then you find an appropriate remedy. The new thinking in competition policy really is you have to have ex ante rules enforced by a regulator for a particular group of companies or an industry. And instead of trying to find a violation and proving it in court, you set up a set of standards for promoting competition. So I do think if you go through each of those policy areas, once after another, you'll say you need a regulator to do the job. One of the innovations of the book is to say it's not enough just to say you need to have a regulator. You also have to have the same regulator. And I think if there's one takeaway from the book that might be a little bit more controversial than others, it's that. In the United States, it turns out we're kind of inching towards that, or as someone said the other day, falling backwards towards that. When Congress was looking at this disparate group of policy discussions, not in this Congress, but in the previous Congress, they were looking at reforms of competition law for digital industries. And they said, we need a set of rules and regulations to be applied by the Federal Trade Commission when they looked at privacy law, a national privacy law that would establish for the first time a set of constraints on businesses acquiring and using information on a national level. They said, we need a regulator. Let's make it the Federal Trade Commission. And then when they looked at content moderation and said, we need someone to supervise transparency requirements, let's make that the Federal Trade Commission. Sort of in this strange, siloed way, they were in effect labeling the Federal Trade Commission as the nation's digital regulator. And I think almost by accident, that turned out to be the right institutional structure. And the reason for that is that these policy areas, all three of them, overlap in significant ways. I think ultimately that's not an accident, because each of these policy areas in digital industries revolves around information. Privacy is clearly about personal information. Data and data access is key to competition in digital industries. And content moderation is a matter of looking at and carefully controlling the kind of information that's spread on your social media platform. So information is the key linchpin that links these three different policy areas as they're applied to digital industries. And so it's not surprising that any measure that advances the ball in one of those policy areas will have implications in the other policy areas as well. And so it's really important to think about these issues from a holistic perspective. What are you trying to accomplish, and how do you think the different policy measures are trying to get to those goals?
So Mark, my instinctive reaction, even at the title level, you say digital industries, every company that I talk to, they could be making cement and they are a tech company and they are a digital company. And, in my early internet days, 20, 30 years ago, the internet was a sector and it was different. But, is Walmart a digital company? It has a huge digital business. Okay, Amazon's digital is bigger, but Walmart's is this and that. Amazon's got stores. it's one thing to regulate electric utilities, but we wouldn't today regulate businesses that use electric versus businesses that use steam definitionally, if in theory they're all becoming a digital wallet. I was just talking to a company that's talking about their digital wallet. I mean, what is a digital wallet? It's just a concept, right? So
Right.
is it, clearly there are some very big companies, but they're in different businesses, and there are others in each of those businesses. So why, we have other government agencies that are regulating employment, that are regulating health. Is digital health different than health when health is health?
Right. I got you. So here's how I try to address that, because I agree with you. Digital is just about everywhere. I do think there's a concept that you can draw on which says, is the digital part really essential to what you do as a business? But I don't rely on that in the first instance. I take the same strategy that the competition reform bills did in the House and Senate, which is you enumerate the industries that you're concerned about. You just point to them. You say, I care about social media. Here's the definition of social media. I care about electronic commerce. Here's the definition of electronic commerce. I care about search. Here's the definition of search. I throw into that some ad tech as well, because I think the competition problems there are so severe. And also the mobile app infrastructure, once again, because the competition problems are so severe. So why pick those rather than any others? Two reasons. One, that's where the problems are, right? You look at privacy issues, you look at competition issues, you look at content moderation issues, and they are all severe in those 5 industries. And then the second reason is that these are not just sort of random industries off at the edge of the economy. They're central to the way we live our lives in the 21st century. And as a result, if things go wrong there, things go wrong in an essential central part of our lives. And so we would have to take a careful look at creating a regulatory structure to prevent those harms in those essential areas. So that's how I try to get around the problem that digital is a little bit of a fuzzy concept and can't be relied on to narrow the scope of a regulatory agency.
Well, you mentioned the FTC, let me raise one point, at the front, and I think you agree with this in the book. Having a baseline data protection law is in some ways a precursor for the effectiveness of a lot of these other things that follow. I've argued that it's very hard to do competition regulation when companies say, well, I'm doing this for privacy, I'm protecting my apps and so forth. And when we don't have a baseline that says, well, this is the law, then it's hard to question or challenge whether someone is giving you too much privacy, too little privacy, and really, doing it for a competitive reason one way or another, right? We know slave labor is wrong, and if I'm undercutting you by, treating my workers improperly,
right?
I know we're doing something, wrong. Data protection, we don't know what the legal baseline is. Do you agree that we need to start initially with a privacy law? And let me just add to that, because the FTC has, in theory, although it seems like the competition side of the house and the privacy side of the house don't always talk to each other, in theory, we have a regulator that is supposed to be doing both competition and privacy. There was recently an action against IQVIA, which I thought was amusing from where I sit, at least. On one hand, the FTC is out there saying tracking health, tracking non-HIPAA health, very problematic, very concerned. Are people being targeted for having a particular disease? Are there pixels on, hospital sites or health-related sites? A lot of concern. And then on the competition side of the FTC said, we're worried about IQVIA buying another player in health advertising because we're worried that they won't provide the data needed for competitive health-related advertising.
Right.
I just thought, could you all have a meeting back?
Could you ever talk about this? Yeah.
But so the point is, even at one regulator, you
right.
can have crosswise. The FTC, I guess, needs the privacy law first so it can figure this out. But why aren't we reforming the FTC to be the regulator you want? and giving them a law to do privacy so they can actually figure these things out for us?
Well, that to be clear, I think what I'm suggesting requires new laws. You can't just sort of say to the FTC, please do privacy competition and content moderation. God bless you. You need new laws, and so privacy is one of those laws that I would give to the Federal Trade Commission initially. The competition reform stuff would go to the Federal Trade Commission as well, and the content moderation stuff would go there. So I think you do need to have new laws. You can't just hope that they, out of the goodness of their heart, begin to do the right thing here. But one of the important reasons to put it in the same agency is precisely to avoid the kind of conflict that you just described. And of course, if you put it in the same agency and then they don't talk to each other, well, okay, that's a problem. But I think it's even worse if you had separate agencies working at cross purposes. And just to be clear, I mean, these kind of conflicts are not just a matter of not having the appropriate law. It's now you've got the law, how do you make it work? And I think our friends over at Ofcom are beginning to confront this as they begin to put in place the recommendations, the requirements of the Online Safety Act. They're required to do some material that would protect children against recognized harms. And to do this, they have to have proposals in the area of age assurance. They have to have proposals in the area of encryption, and the guidance that they've got gives them full and complete authority to make decisions in that area. They're happy to talk to the Information Commissioner's Office and say, tell us what you think about privacy in this area. Are age assurance guidelines appropriate from the point of view of privacy? But ultimately, at the end of the day, they are the ones who are required under law to make the ultimate decision. And there's a cooperation forum that they're all supposed to sit down at and talk, and there are consultation requirements and so on. But at the end of the day, if Ofcom says, here's how we're doing age assurance, that's how age assurance gets done. And if they say, you know, we think we can find a technically feasible way of breaking encryption, and we don't think that's a privacy problem, off we go. So those kind of, you know, decisions that have to be made by a particular regulator, you know, have to balance these different considerations. And if you put the decision-making power in an agency that has a single purpose, online safety, then I think the balance might not be set properly. You could even get a situation, if you're not careful, where one of the agencies says to do something that the other agency says is against the law. And then if you're in a company, the first thing you do is wander off the court and say, tell me which one of these requirements I'm supposed to live under. So I do think you've got to have some sort of mechanism for resolving these issues.
And I think you're right that in the UK this will work out.
In the States, I think you do it by putting it in the hands of the Federal Trade Commission and giving them a mandate to resolve these kind of tensions. And to seek out, frankly, there can be synergies in these areas too. So to seek out the synergies as well as to avoid the tensions.
And I think you're exactly right that in the UK, the process is going to encourage or even force that sort of cooperation. We held our annual Brussels Privacy Symposium a week ago and had regulators from the multiple new agencies and the data protection regulator. And it's clear that the multiple European laws are heading for a clash, even though the language says, well, this has got to be compatible with, you know, GDPR requirements. The data protection regulators certainly feel quite strongly that their independence and their special status under the charter gives them the final word. And it's quite clear that some of the other regulators equally feel that they've got the final word. So I fear we're headed for a lot of stress. But why then can't we take the FTC? I mean, you're calling for a new agency. Are we stripping out the FTC's authority here? The FTC has the competition piece. Let's leave the content. I'm going to discuss
Yeah, they're separate.
The efficacy of the U.S. government being involved in content, in the content regulation or the transparency of content regulation. But let's take just maybe the easy part of competition and privacy. Is it just a matter of refining? FTC is a very old agency with old authorities. So in addition to a privacy law, and you're right, they act as an enforcement agency sometimes more than although they have their rulemaking authority. Are we simply, can we just give the FTC a digital division with a team that focuses on the high priority companies? Why strip it out? And if we do strip it out and you don't take away their authority, well, they're still going to be the consumer regulator for what are obviously privacy issues as well. How do you think about that? So
I think there are a couple of pieces of legislation that go directly to a digital agency. Senator Welch and Senator Warren have separate bills doing that. I think as a practical matter, the way Congress will do this is to send it off to the Federal Trade Commission. And I think ultimately it will become clear over time that it's not quite the right institution for the job. Their history, their tradition is essentially as an economy-wide law enforcement agency. They focus on companies all across the economy, and they tend not to pass regulations and then enforce them. They tend to create cases that they bring to court and then ask a judge to impose a remedy. And I think that's totally different from the approach that a sector-specific regulator takes. If you think of the way the Federal Communications Commission functioned over time, they set up rules to promote competition in broadcasting. They set up content rules of fairness doctrine, kids TV. They imposed requirements on cable companies. They imposed requirements on satellite companies, and now they're looking to put requirements on internet service providers. They pick the industry that's under their jurisdiction, and they tell them what to do by passing regulations and then enforcing those regulations. Can the FTC do that? Yes, but it's not what it's done, and it don't have a history of it. And so I think it's an experiment to put that kind of responsibility with the Federal Trade Commission. If it works out, I'm just fine. I have no editorial, compunction to say we need to have a special digital regulator. I'm a practical person. So if it works, I'm okay. But my prediction is that it won't. And so we'll eventually have to strip that authority out from the Federal Trade Commission and put it in a separate agency. And if someone said to me right now, okay, you can pass it through Congress to set up a new digital agency, you got the votes, I'd do it that way, because I think it's a better process to have a sector-specific agency with rulemaking authority than it is to try to impose that on the Federal Trade Commission. I think as a practical matter, I don't have the votes and I can't do it that way. So I would do it in a two-step. FTC first. If it works, stop. If it doesn't work, go on, as I think you'll need to a sector-specific agency.
Well, I do love your vision of putting the FTC on notice that its current method of regulation falls short for what is needed. I've argued over the years to some of the commissioners that, and look, maybe I'm a bit biased by the fact that I work with a lot of the folks who are on the compliance side, and most of them want to do things right to the best of their understanding. And when they can clearly say, this is not allowed, and here's why, they will throw their bodies in front of it. And of course, there's exceptions and there's bad actors. But often that's not the case. Often there's this vast gray zone, and it's because there's been some settlement, but it's not really clear that that's applicable broadly, and so on and so forth. And the FTC, whether it's by exercising rulemaking more effectively with, perhaps legislative changes that can help them rulemaking and a clear statute with a lot of detail, or frankly, even using the mechanisms they have when they post things and when they speak and when they issue guidance, they've got if somebody can point, I find that we have companies that say, what's your view on this? And I say, well, could you just post something about that. We would love to be able to point to something that in this particular thing, that means that, and that would let us take it back home. But when we go to the business people and we say, we shouldn't do that, and they say, well, where is the law clear? No. Do our competitors do it? Well, we can't tell. Maybe they do, maybe they don't. The FTC can and should step up. All right, let's talk about content moderation then, because, agreed, privacy, we need a law, we need a regulator, fine. Competition, we have multiple regulators, there can be improvement. Content regulation is, I guess, the big challenge. We see some court decisions telling the government to pull back some of the way that it is interacted with these platforms. We have very divided views in this country about what is appropriate and what is not. We are deeply divided, and at this time of conflict in the Mideast, where I'm really following so much on social media, I see prominent people on every side, accusing each other of complete bias and anti-Semitism, and
Right.
And do we really expect that the government experts are going to be in the U.S. with our First Amendment concerns and our divided views? Is simply better transparency about how people who are sitting at the consoles make decisions using AI that this sounded anti-Semitic to me because here's what I think about what the words from the river to the sea mean, and here's what someone else thinks not. Like, and how can the FTC or the digital agency conceivably take this on?
Yeah, that great question is clearly the most controversial, especially in the United States with our First Amendment values and tradition. But I do think there's enough of what I call information disorder on social media to justify a government role. And you're right, I focus on transparency as the way forward. But for me, transparency really has three parts. And I think those three parts together will provide a regulatory structure that will improve things and also show the way forward if further steps need to be taken. So the first part is just basically a transparency as part of a due process system that the social media companies should live up to. You tell the people who use your social media platform what the rules are. You give them an opportunity to complain when something goes wrong. If something is a violation of your terms and conditions and you want to take a step to sanction, you've got to give people an explanation. You've got to have a redress mechanism. All of that stuff is just standard accountability mechanisms to make sure that the process you're running for content moderation is fair. And so that's the first part of transparency. The second part is the kind of stuff that's set up in the European Digital Services Act and the Online Safety Act in the UK as well, a process of required public reports which contain your risk assessments of the dangers or harms that you think might be contributed to by your systems, and then the mitigation measures that you put in place to try to control those harms. You can even have external audits of that function that the company could bring to bear to make sure that they can't just make stuff up and that there's an independent check on that. That's the second area of transparency. The new element in that area, because the companies do that right now to some degree, is that the measures that you might have in these public reports of how well they're doing in their mitigation efforts might be measures that would be set by the government rather than set by the companies. So if you have suicide material that's present on your social media company, you can report the presence either as it's 0.00001% of our content, or you can say 10,000 people under the age of 18 were exposed to this. And one of those tends to show the problem as small, the other tends to show the problem as large. If you're the company, you want to show it the way that indicates the problem is small. If you're seeking to do something about it, you might have an interest in hearing the other measurement. And the regulator would be in a position to say what sort of measurement you should come out with. And then the third area of transparency, I think, is really crucial. It's in the Digital Services Act. It's a requirement for data access for vetted researchers. So suppose you've got a research project and you want to make sure that you have access to enough information from social media companies to verify whether some of the problems that are allegedly the social media companies contribute to it is real. You can go to the regulator and say to the regulator, here's my project, I'm a legitimate researcher, I need access to this information, and they'll create a mechanism whereby you can extract that information from the companies with due protection for privacy and for intellectual property. Right now, that access to information is controlled entirely by the companies. And if they don't want to give you the information because they think it will invade someone's privacy, they don't do it. And a number of these research projects have fallen apart for lack of an outside decision maker. If that regulator can be that outside decision maker, I think you'll see a blossoming of legitimate research projects that will help us understand more about what's going on these systems and what we might be able to do to prevent the harmful stuff.
Well, I hope Mark has helped you all understand a bit more about how to regulate digital industries and some of the options. Really encourage folks to read the issue, read the book, both for an overview of the key policy, politics, and developments in privacy, in competition, in content moderation, how these agencies work. I really enjoyed it, and look forward to keeping it on my shelf for future reference. Thanks, Mark, for joining us today. Folks, buy this one. You'll appreciate it. And please keep an eye on Mark's ongoing work, his commentary at Brookings and in other op-eds and so forth. Always adds some real insight from his unique multidisciplinary background and vantage point. Mark, really good to see you. Have a good weekend and good holidays, and see you around town here in DC.
Thanks, Jules, for having me.
Pleasure.